What will be H-1B issues in 2022? I'm your host, John Veely, immigration attorney and CEO of Online Visas, the intelligent immigration platform. If you'd like to learn more about what we cover in this video, go to onlinevisas.com. H-1Bs are still complex, cases still get denied, and improper processing can result in allegations of fraud. This can result in criminal convictions, loss of corporate assets, and deportation for owners and employees. The Fraud Detection Unit, and FDNS, is well funded and has an all-time high number of USCIS and DOL referrals lately. Now that adjudicators are not permitted to require third-party contracts, itineraries, letters, and site visits, emails and calls from investigators to owners and beneficiaries, third-party clients, are becoming more prevalent. Here are the following issues that will be important this year. Employee-employer relationship. While proving through third-party letters are no longer required, the petitioning company is still needed to be the actual employer. This issue is verified through meeting at least one of the hire, pay, fire, supervise, or otherwise control the work of factors. Establishing this in client contractual language, employment agreements, employment handbooks, and even on invoices consistently can address this. Another tip is using project management software or communication to establish oversight of beneficiaries who clearly work off-site. Multiple companies with same owners. Investigation RFE and 221G consulate denials for H-1B employees of companies owned by persons who own numerous companies has seen a recent uptick. These investigations may be seeking information that indicates the other companies were created to avoid higher filing fees for companies that are H-1B dependent. Many related companies are formed for legitimate reasons, including strategic processes, different skills, different business channels, etc. If you have multiple companies to avoid or address this issue, there are many things to consider. Specialty occupation. Probably the most analyzed issue. USCIS has changed some of the more restrictive thinking on this, like the bizarre distinction between programmers and developers, but it still uses the more restrictive Occupational Outlook Handbook instead of ONET as its database for acceptable jobs and the requirements for specific educational degrees. ITServe case removes USCIS's strategy of meeting multiple criteria under the specialty occupation regs instead of just one. Some strategy to meet additional criteria is OOH analysis, which is how USCIS determines criterion 1, is to show that the company has a history of hiring with the same or similar degree by collecting degrees in employment proof of others that is the norm in the industry, or to hire with identical or similar positions by collecting want ads similarly sized companies. Educational requirement. While the ITServe case received the most notoriety for changing H-1B policy, other cases had a significant impact also. Some that did so in the educational requirement issue is Inspection Expert, or IXC. It holds that USCIS cannot require a degree in just one particular subspecialty for a job to qualify as an H-1B specialty occupation. The court, relying on the holding of the Supreme Court of the United States in Kaiser versus Wilkie, found the USCIS interpretation of the H-1B regulation was unreasonable and not entitled to deference. An engineering degree requirement meets the specialty occupation degree requirement. Consular processing. Two interests of the Biden administration may be favorable immigration policy and COVID-19 related health issues. These policies come in conflict in the realm of consular processing and are both fluid and inconsistent. 221G denials has become a standard response. The national interest exemption has been a tool for countries that have had travel bars until November 2021. The national-based bans were eliminated, which resulted in a wave of people trying to get into consulates around the globe, impacting every industry. Site visits investigations. These can be random, but may not be, and you may not know. Your participation is voluntary, and what you say or write can be and will be used against you. There is no one-size-fits-all way to deal with it, or any of the questions or situations that are part of the process. Dealing with them requires precision, and all communication, no matter how early or small, may make the difference in what happens. Hire an attorney and let them answer and speak for or on your behalf. Never do any part of these on your own. If you want to discuss your company's situation, go to onlinevisas.com and set up a strategy session. If you want to stay up to speed on the ever-changing world of immigration by subscribing to Online Visas, like, share, and follow us on Facebook, Twitter, LinkedIn, Quora, and Instagram. I'm John Veely, CEO of Online Visas, the intelligent immigration platform where we deliver dreams.